Good afternoon, everyone, and welcome to our webinar this afternoon on the UN Convention on the Rights of the Child Bill and Scots law, and in particular what the bill will mean for central government, regulators and public bodies. This is a seminar being presented by myself, Christine O'Neill, and my partner, Charles Livingston. We're both partners in our government regulation and competition team, and post-lockdown, we're both looking a little bit older than our photographs, but I promise you that is us. If I can also just mention that today is the first of a series of 5 webinars that we are hosting on the UNCRC bill. There are 4 more to come in a packed fortnight in June, beginning with a session on the 2nd of June, in which we have a number of young people who are going to be, for their sins, in conversation with me, talking about the UNCRC, what they expect of the bill, and indeed talking about topics well beyond the UNCRC. We also have a session specifically on local government. We know we have a number of colleagues today joining from local government, and you're very welcome to do so. There is a session designed specifically for local government colleagues on the 3rd of June, then for the third sector on the 10th of June, and then we're hosting a debate. Charles is going to be in the hot seat for that, hosting a debate among young people about whether the UNCRC bill is a good or a bad idea. In the meantime, the agenda for today is on this slide. I'm going to speak to most of these bullet points around what the convention is and how it's being implemented in Scots law. Charles is going to take the last of these bullet points on the effect of the bill on other legislation, and as part of that discussion, Charles will be talking about why we are still talking about the UN Convention on the Rights of the Child Incorporation Scotland Bill rather than the UN Convention on the Rights of the Child Incorporation Scotland Act, and he'll touch on the reference that has been made by the United Kingdom government to the Supreme Court in relation to the bill. Now, notwithstanding that reference, we do expect the bill to receive royal assent in due course. That's not because we know what the Supreme Court will decide, but because the reference is on a number of specific provisions and how they interact with UK public bodies. But we expect the main provisions to be brought into force in short order after the reference has concluded. And I should probably just say then a little bit about timescale for implementation. As originally drafted, the bill would have come into force when Scottish ministers made an order bringing it into force, and the intention had been to allow a flexible period for implementation to let public bodies in Scotland get up to speed with the requirements of the Act. That approach to commencement was the subject of some criticism and challenge, and there was an amendment made to the bill during its passage to make it plain that the main parts of the bill would come into force 6 months after royal assent. So we've not had royal assent yet, but when royal assent is granted, the bill will come into force for all purposes within or after 6 months beyond royal assent. So you're in a relatively short period for implementation. The view of the Scottish Parliament's Equality and Human Rights Committee, which produced the Stage 1 report on the bill, was that shouldn't be a problem because most public bodies in Scotland should already be acting in a way that is broadly compatible with the requirements of the Convention. And if we move on, I will just remind you of what I'm sure you already know, that the UNCRC is an international human rights treaty that was adopted by the General Assembly of the United Nations in 1989. It has been adopted and ratified by the United Kingdom, but again, as you will know, the ratification of a treaty by the UK does not give it legal effect within the United Kingdom without something else being done, or at least not legal effect that allows people to go to court to enforce their rights in the way that they will be able to after this bill comes into law. There are 54 articles in the UNCRC. We absolutely don't have time to look at them all this afternoon, but I do want to mention just 4 of them, which are regarded as particularly important. these are considered to be the general principles underpinning the UNCRC and which are used to interpret the remaining articles of the Convention. Article 2 is about non-discrimination and is what you would expect, that the rights provided for under the Convention are to be enjoyed by all children without discrimination on grounds of race, religion, political belief, and the usual grounds, if I can call them that you would expect to see in a non-discrimination clause. Article 3 provides that in all actions concerning children, the best interests of those children or that child shall be a primary consideration. Not that it is the primary consideration, but a primary consideration. And that extends to ensuring by the state that there are measures in place to protect and secure the welfare and well-being of children. Article 6 is the right to life, but it goes beyond simply a right to life. It extends to conferring on children a right to the fullest extent possible to be in a situation where they can develop as well as merely live. So it's a right to life, survival, and to development. And then Article 12, which I think is liable to be an article of particular importance to many of you attending this session this afternoon, and I suspect an article which is likely to be one of those that becomes the subject of greater litigation in due course. Article 12 is the right to be heard, and that's an article which provides that for children who are capable of forming their own views, they should be entitled to express those views in all actions or decision-making affecting them, and that their views should be given weight in decision-making processes. So we can come back to all of those in due course, but those are the particular articles that you may want to have in mind. There are many others. The UK has also ratified 2 protocols to the UNCRC, but until now it has not been incorporated directly in UK or Scots law. And that is until now. So if we move on to this slide is intended to illustrate that while the Convention itself hasn't been formally incorporated in its entirety in the way that it has been by this new bill, Scots law has not ignored the UNCRC, and all of these measures, to one extent or another, have been intended to give effect to certain principles protected by the UNCRC. What's interesting about all of these pieces of legislation is that rather than, if you like, cutting and pasting the actual articles of the UNCRC into Scots law, they have taken those articles and in a sense given them flesh through very specific statutory provisions in each of these pieces of legislation. Many of these will be familiar to you, and again, I don't intend to go through them all in any detail. Perhaps the most recent of these is the Children's Scotland Act of 2020, interestingly a piece of legislation that was being passed just at the same time as the Incorporation Bill was going through Parliament and received royal assent last year. It's particularly concerned with ensuring that children are able to participate effectively in family law proceedings in the court, but you will see there the range of contexts and situations in which the UNCRC has been given more limited effect in Scots law. So if we move on, I've mentioned that the UNCRC is not currently enforceable directly in Scots law. Again, that doesn't mean that the courts haven't had regard to the convention already. And what the courts have done in the context of the UNCRC is what they've done in the context of other international measures, which is to say that those measures, although not directly enforceable, can be looked at to help the courts understand and interpret statutory provisions within Scotland or within the UK. And that to some extent is based on the principle that the courts will intend that Parliament has wanted to, or the courts will take the view that Parliament has intended that its legislation should comply with the UK's international obligations. So if we look at a piece of legislation and an international measure is relevant to that legislation, the courts will take the general view that Parliament intended to act consistently with what the UK is bound to do as a matter of international law. And so, for example, in the Christian Institute case, which again, many of you may remember, this was a challenge that was brought by the Christian Institute to the Scottish Parliament's legislation on the concept of the named person. The UNCRC was used in argument, and it was cited by the court in its judgment in the court's interpretation of Article 8 of the European Convention on Human Rights. So again, quite an interesting aspect of the UNCRC is not that it's just used to interpret black letter legislation in Scotland and in the UK, but it is also used to interpret other human rights measures, including the ECHR. And we have seen in the Scottish courts, the Scottish courts looking to the convention itself to interpret domestic legislation. In the three cases that are mentioned on the slide, these are predominantly in relation to the question of children's views on what should happen to them in family law proceedings and how the courts should go about giving weight to those views. So really just to explain that this is not absolutely brand new to the courts. They have been thinking about the UN Convention on the Rights of the Child already. What is different is that they've not had to interpret those rights in a freestanding way, in the way that they may do now with the convention being incorporated into Scots law. They're going to have to interpret those rights in the way that they've been interpreting rights under the European Convention on Human Rights. But what they don't have to help them in the way that they have with the European Convention on Human Rights is they don't have the equivalent of the Strasbourg court. They don't have a body of jurisprudence from a court whose job it is to interpret the UN Convention on the Rights of the Child. So the courts in Scotland will be faced with a really quite novel task if and when people bring to the courts questions about whether their rights have been respected under the UNCRC bill. So if we just move on, what is being done by the bill? Well, the intention of the bill is to incorporate the UNCRC so far as it's possible to do so in Scots law, and I'll leave Charles to talk about what that might mean. It creates not an offence, but a category of unlawfulness, and it will be unlawful to act incompatibly with the incorporated UNCRC requirements. And the people who might be subject to challenge on the grounds that it is acting incompatibly are public authorities and anyone undertaking functions or providing services to children using public funds, and indeed in some cases when they're not using public funds. It gives new powers to the Children's Commissioner to take legal action, and it imposes proactive obligations on both the Scottish ministers and on listed public authorities. And I just want to spend a little bit of time talking about these proactive duties that are imposed by the bill on ministers and on listed public authorities. So the Scottish ministers are required to produce a children's rights scheme, and the scheme has to set out the arrangements that ministers have in place and intend to put in place to ensure that they comply with their duty to act compatibly with the UNCRC, but also the arrangements they intend to put in place to secure better or further effect of the rights of children. So again, the scheme is not intended to be narrow, the scheme is intended to be broad in scope. The Act specifies various things that have to be included in the children's rights scheme. And so, for example, the scheme itself must include arrangements for ministers to ensure that children can participate in the making of decisions that affect them, and that those children have access to support and representation. The scheme must include provisions about promoting complaints handling processes that children can access and use. The scheme must make provision for arrangements to ensure that children have effective access to justice. So the children's rights scheme that ministers will be putting in place will affect what ministers themselves do, but it's quite clear that the scheme will be going beyond that in terms of ministers including within the scheme expectations about what others will do to ensure and facilitate the better protection and enforcement of children's rights. The scheme has to be reported on an annual basis, and there is provision for the scheme to be updated as and when it's thought appropriate to do that. So we have it at the Scottish Government level, the Children's Rights Scheme. You also have, in relation to the ministers, the requirements in relation to children's rights and wellbeing assessments. So in various contexts, including when ministers are considering new legislation, whether that be primary or secondary legislation, and when they're taking decisions of a strategic nature relating to the rights and well-being of children, they have to carry out children's rights and well-being assessments to consider the impact on children's rights of that proposed action. In addition to the obligations that are imposed on ministers, I've mentioned that listed public authorities require also to take action, not on an annual basis, but on a 3-yearly basis. And on a 3-yearly basis, those authorities are required to publish reports explaining again what they are doing and what they propose to do to ensure compliance with their obligation to act compatibly with the UNCRC requirements, and what they intend to do to better secure children's rights. Among other things, the report that must be published has to be also published in a child-friendly format alongside any main report. And the listed authorities that are covered by this obligation include local authorities, includes Children's Hearing Scotland and the Children's Report Administration, health boards, Scottish Qualifications Authority and Skills Development Scotland, the SSSC, Scottish Police Authority, and more. So a very wide range of listed authorities are required under the Act to report on this 3-yearly basis on compliance. So those are, and I should also say there is a parallel duty on the Scottish Parliament itself to report on how it's also dealing with these matters and to report on an annual basis. Those are proactive obligations to take action and to take steps to protect children's rights. If we move on then to perhaps what many people see as the meat of the bill, so on to the next slide, these are the provisions of the bill that give individual children, and as we'll come to the Children's Commissioner, rights that can be enforced in the courts, and sets out a scheme by which those rights can be enforced in the courts. And the first thing I think to say about these provisions of the bill is that if you are a lawyer who is regularly advising public authorities and you look at these provisions of the bill, you will see very many similarities to the Human Rights Act. So very much of this scheme bears a striking similarity to the provisions of the Human Rights Act, and many of the concepts in these provisions look very much like what you would see in the Human Rights Act. So first of all, Section 6 of the bill provides that public authorities must act compatibly with the UNCRC requirements, and it will be unlawful for a public authority to act, or indeed to fail to act, in a way that is incompatible with the UNCRC requirements. And I appreciate that there is a slight contradiction or double negative in that sentence, but a public authority must not act incompatibly, and an act can include a failure to act in this context. There isn't a list of public authorities to which this provision applies, and that's because the bill takes the same approach as has been taken in the Human Rights Act to the concept of a public authority. Human Rights Act doesn't contain a list of the public authorities to which the Act applies. Rather, it's left to the courts to take a view on what kinds of bodies do or do not fall within the scope of the concept of a public authority. And what's key to that is what the body does. So if a body's functions are of a public nature, it will be considered to be a public authority for these purposes. And that includes organisations that are ostensibly private sector organisations. They will be excluded to the extent that any particular act of theirs is a private act, but where private sector organisations are exercising public functions, then they will be public authorities for the purposes of this bill. And the bill doesn't specify the functions to which the section applies, and that's because it applies to all functions of public authorities when they are being exercised. So that's section 6, that's the general duty to act compatibly and not to act incompatibly with the UNCRC requirements. The next question is, what happens if you do act incompatibly with section 6? And before I get to that, I'm skipping ahead. There are a few things I suppose to be said in addition on the effect of section 6 itself. For those authorities that are subject to section 6, what will be important is that you embed the UNCRC requirements in all of your decision making. This is not a duty like the public sector equality duty to have regard to particular requirements, but it is a duty to comply in substance with the bill. And if you fail to comply with UNCRC requirements, then a child or someone acting for the child could raise proceedings against the authority where there has been an alleged breach, or indeed where it's anticipated that there will be a breach. And one of the examples that's given, for example, is where there's an argument that in making a decision, the authority has not had regard as a primary consideration to the best interests of the child. And I suppose the last thing to say, and I've alluded to this already, is that the UNCRC articles are drafted in fairly wide and open textured terms. They may prove to be difficult provisions for the courts to interpret and apply. And because of this absence of existing case law on what these articles mean, there will be a degree of latitude for the Scottish courts when interpreting the convention, and it will be interesting to see what they do and how they go about that. So if we move on to section 7, this is the provision that allows for proceedings to be brought against public authorities, and it applies to any public authority that has acted or proposes to act in a way that is made unlawful by section 6. Proceedings can be brought in a court or tribunal alleging that the public authority has or proposes to act in that way, and that can be brought as a freestanding claim against the public authority. Again, very much in line with how the Human Rights Act works, there is a 1-year time limit on the bringing of claims from the date on which the act complained of took place. There are two caveats to that. The first is that 1-year time limit is without prejudice to stricter time limits that apply in particular court processes. And so the 3-month time limit that applies in judicial review proceedings will still apply where a judicial review is raised in relation to the UNCRC bill. And importantly, and this was thought important to protect the rights of children, the time limit will not apply to any period during which the person making a claim is under 18. So for the time that a child is under 18 years old, that time is disregarded in calculating the 1-year time limit from the act complained of. Now, the other thing just to mention is that even though there is this 1-year time limit, and even though there is a 3-month time limit for judicial review, in each case, the court does have a discretion to extend those time limits if it thinks that it's fair to do so. So neither of those time limits is an absolute guillotine. Again, if we move on, if a court finds that there has been a breach of the convention, the court can make a range of orders. And I suppose importantly for those of you who are going to be subject to the Act's provisions, it will be possible for the courts to make awards of compensation or damages. for breaches of the UNCRC. What's anticipated in terms of the way those damages or compensation payments would be calculated is that the courts would approach that task in very much the same way that they approach the task of working out the level of damages for breaches of the Human Rights Act. So under the Human Rights Act, again, as you may know, there is the concept of just satisfaction, what's required to afford a claimant just satisfaction. That concept is also to be used here in calculating damages that might be payable for a breach of the bill. And again, by amendment, there was included in the bill as passed provision that makes it clear that when the courts are looking at what they should be doing by way of making orders, that the child should be given the opportunity to express their own view on the effectiveness of what is proposed by the court. I've mentioned the possibility of judicial review. Again, we could have a range of different forms of court action brought under the Act. Judicial review is certainly one of those, and it might be an action or a petition for judicial review brought alleging that the public authority has acted unlawfully. It goes without saying that public authorities will want to be able to demonstrate compliance with the requirements of the Convention in order to defend proceedings because of the risk of financial harm and indeed of reputational harm through failure to do so. We can talk a little bit more later about how you might go about doing that, but certainly given the timescales that we're talking about for implementation, we would be recommending that any organisation subject to the bill is thinking very carefully just now about its functions, about the extent to which those functions touch on children and potentially the rights of children, and looking at the requirements of the Convention to be alert to the range of rights that are conferred by the Convention and the range of circumstances in which the rights of children might now play into your decision making when you're exercising your functions. So if we move on, my last slide just deals with the Children and Young People's Commissioner, and it's simply to mention that the bill strengthens the functions and powers of the Commissioner by, in particular, giving the Commissioner himself the power to bring proceedings against a public authority for non-compliance with the Convention, and indeed to intervene in proceedings where someone else has brought a claim, but the Commissioner thinks they have something to add to the argument. And this brings, if you like, the Commissioner onto a very similar footing to regulators like the Equality and Human Rights Commission. And in addition to giving the Commissioner these powers under the bill, again, by amendment before the bill was finally passed, similar powers have been given to the Scottish Commission for Human Rights. So there are now a range of organisations as well as individuals who will have the potential to bring proceedings in court in relation to the UNCRC bill. I'm going to hand over now to Charles to talk about some of the more interesting constitutional dimensions of all of this.
Thanks, Christine. Okay, here's where we get really nerdy. The bill contains a number of provisions setting out what the Scottish Parliament intends the consequences of the incorporation of the Convention should be on other pieces of legislation. Now that to some extent follows the approach or the trail blazed in respect of that sort of thing in the Human Rights Act and in the Scotland Act itself, which obviously places parameters around what the Scottish Parliament can do. So I'm going to go through some of those provisions, and hopefully for those of you who have some familiarity with the Human Rights Act and the Scotland Act provisions, they will ring some bells with you, I think. But in terms of the policy taken to this question, the Scottish Government has described its approach as a maximalist approach, so seeking to secure maximum protection for children's rights. But obviously the Scottish Parliament's powers are constrained under the Scotland Act, under the devolution settlement. So there are limits on what the Scottish Parliament can provide for in relation to the convention's effect on other pieces of legislation. It may be proof that the Scottish Parliament has taken a maximalist approach, that the UK government has expressed concerns that it has actually exceeded its limitations. So the UK government's expressed concerns about the bill, and as Christine mentioned, has referred it to the Supreme Court for a ruling on its lawfulness, essentially, on whether it's within legislative competence. Now, as Christine mentioned, that's on a few narrow issues, some of which I'll be taking you through. It's not about the policy or the general ability of the Parliament to incorporate international conventions into Scots law, but it does mean that the bill won't receive royal assent in the meantime. So in terms of the reference itself, it is, as far as I can tell, not in the public domain, the precise terms of the reference. If it is, I haven't seen it. But what is in the public domain is correspondence between the Secretary of State for Scotland and the Deputy First Minister from when the bill was going through Parliament, and in particular towards its later stages. And that identifies where the UK government has concerns. And one of the areas where it has concerns is that the obligations that Christine was talking about in terms of public authorities having to comply with the UNCRC principles, that doesn't distinguish between authorities that are carrying out devolved functions that are within legislative competence of the Scottish Parliament and UK government excuse me, entities that are carrying out reserved functions. So the UNCRC is unlikely to be engaged too often, but the Ministry of Defence has plenty of facilities in Scotland, but is not generally subject to the jurisdiction of the Scottish Parliament because defence is not within legislative competence. So I think that broad scope of the obligation that doesn't make that distinction is one of the areas where the UK government's correspondence, which you can, if you've got a big enough screen, you can make out the start of that in the corner of the slide. That's one of the areas where the UK government has identified a concern, and so I think we can presume that that forms part of the reference. So if we move on, I'll take you through the key provisions of the bill. For reference, we've added the section numbers. The section numbers will change when the bill finally receives royal assent, because some provisions were added by amendment and will need to be renumbered when it becomes an act. The first provision is pretty anodyne, so statements of compatibility. Any MSP who's introducing a public bill in the Scottish Parliament has to include a statement about the bill's compatibility with UNCRC requirements, in the same way that a statement has to be included that the bill is within the legislative competence of the Parliament. The Scottish ministers, in addition to that, have to make a statement about the compatibility with the UNCRC requirements of pretty much any secondary legislation that they make. Now that is going to be, I think, pretty broad ranging. It does mean that the question of compatibility will always need to be asked, but it means that it will need to be asked in areas where there is potentially no prospect of the UNCRC requirements being engaged. I guess the function of the obligation is to make sure that people are not just assuming it won't be engaged. But nevertheless, certainly in terms of secondary legislation, there will be hundreds of items with no likely impact on the UNCRC requirements that will still need to contain a statement. I put a question mark on the concept of justiciability here. I think it's almost certainly the act is not expressed, but it's almost certainly the case that any failure by an MSP to make a statement about compatibility will not invalidate a resulting act. But in terms of Scottish minister statements, we have seen judicial reviews of UK and Scottish ministers making secondary legislation where it's said they haven't complied with their duty to make particular statements or have regard to particular issues. So it's possible that in relation to secondary legislation, it might create a ground of action, and we may see some litigation in relation to that. So the next section of the bill is section 19, which concerns the interpretation of legislation. And this is one of the areas, another one of the areas that the UK government has identified as lying behind its Supreme Court reference. So the provision of section 19 will be familiar to those of you who know your way around the Human Rights Act, and it provides that so far as possible legislation is to be read and given effect compatibly with UNCRC requirements. Now you might be asking yourself, didn't Christine already cover that in terms of the courts taking account of UNCRC in interpreting legislation? And it's true that they do that, but when it's placed on an express statutory footing like this, that essentially licenses the court to go further than it inherently has the ability to do, and potentially to give legislation a pretty stretched meaning in order to ensure that it's compatible. And there's a fair amount of case law on the Human Rights Act equivalent to this provision by this stage. The power only applies to legislation that would be within the Scottish Parliament's legislative competence. Now, that's not the same thing as only applying to Scottish Parliament legislation. So it applies to acts of the Scottish Parliament or acts of the UK Parliament that would be within the Scottish Parliament's legislative competence. And it also applies to any secondary legislation that would be within competence, regardless of whether it's made under an ASP or under a UK Act. And it also applies in relation to past legislation, so legislation that predates the point at which Section 19 comes into effect, and also legislation that postdates that. And this is one of the areas where the UK government has an objection. I infer that their complaint will be that by providing for the courts to interpret legislation in a way that may not be intended by the UK Parliament, the UK government's argument, I think, at the Supreme Court will be that the Scottish Parliament has in some way interfered with the ability of the UK Parliament to legislate for Scotland, which is not to get too technical about it, essentially one of the limits on the Scottish Parliament's competence. And that's possibly most relevant in relation to future legislation. I think the Scottish Government's counter-argument will be that if it's within legislative competence, then the Scottish Parliament would have the ability to repeal or amend any such UK legislation. And so on that basis, it's valid for this bill to effectively license the courts to interpret the legislation in a particular way, regardless of which parliament it's made by. So we'll see how that argument plays out. This interpretation requirement has no effect on the validity of the provision in question. One point that's worth noting, particularly if you are a regulator or another body that operates under a piece of legislation, the duty is not said to be specific to the court. So it's not just a court that has to read legislation and give it effect compatibly with the requirements. So essentially, whoever it is that's interpreting or giving effect to the legislation should be doing so in a way that's compatible with the requirements. So if you ever think that the ordinary meaning of legislation that you operate under would require you to act incompatibly with the UNCRC, then this provision may be relevant in terms of requiring you to interpret that legislation differently to make sure that it complies. Now, this and the subsequent sections, the fact that legislative competence is really key to setting the limits of this provision potentially means that questions of whether something is inside or outside the Scottish Parliament's legislative competence might become a much more live issue. To date, it generally defines the scope of what the Scottish Parliament can do and also the scope of what the Scottish Government can do. But this bill applies it almost as a layer that sits over all sorts of other types of legislation and is relevant to how those pieces of legislation have to be interpreted and applied. So we may find that the question of what's inside and outside legislative competence, which is not necessarily easy to answer, is a question that needs to be asked much more often. And it arises again in section 20, which is our next slide. So this is a more draconian power in terms of actually striking down legislation. And it provides that if a court is satisfied that a provision of legislation is incompatible with UNCRC requirements, and it can just be a provision, it doesn't have to be the whole piece of legislation, it may, so it's a power, not an obligation, the court may make what's called a strikedown declarator. And that's a declarator stating that the provision ceases to be law to the extent of the incompatibility. Now that has prospective effect only. So even though this might remind you of the limitations on the Scottish Parliament under the Scotland Act. It's not quite the same. If the Scottish Parliament legislates in a way contrary to the Scotland Act, the effect of that is that it is not law. And so essentially, if you were operating under a piece of legislation and you were sure that it was outside the legislative competence of the Scottish Parliament, you could, if you were feeling brave, ignore it on the basis that the Scotland Act means it is not law and you're not bound by it. Here it's prospective only. So if you're operating under a piece of legislation and it's not possible to interpret it compatibly with UNCRC requirements, you can't simply ignore it on the basis that it's not law. It will only be affected by a strikedown declarator going forward from the point in time that that declarator is made. These declarators can only be made by the Court of Session or by the High Court of Justiciary. I've said they're on appeal or otherwise if it's not sitting as a trial court, or the Supreme Court. You can't get declarators in lower courts. And it applies to, again, any enactment that would be within legislative competence. But in this case, it only applies to an enactment that received royal assent before this Section 20 comes into force. So it's not going to be available for new legislation. Again, it applies to acts of the Scottish Parliament or acts of Parliament or to secondary legislation made under either. And this is, again, one of the sections that the UK government, I believe, is taking up in its reference to the Supreme Court. And the issue there will be whether the Scottish Parliament is entitled to effectively empower courts to repeal acts of the UK Parliament. And again, it's that question of if it's within legislative competence, then the Scottish Parliament could repeal it itself. So why can't it empower a court to do so? The counter argument on the UK government side, well, that's interfering with the ability of the UK Parliament to legislate for Scotland. So we will see how that plays out. But it's relatively novel. So it will be interesting to see how that's addressed. Section 21 is then the last of the provisions that the UK government has expressly complained about in its correspondence. And this is the declarator of incompatibility. I almost said declaration of incompatibility because that's the language from the equivalent provision in the Human Rights Act. So here, this applies to future legislation, which means legislation that gets royal assent after or is amended after this provision of the UNCRC bill comes into effect. So if the court can't make a strikedown declarator because the legislation postdates this section, then what it can do is make a declarator stating that the provision is incompatible with the UNCRC requirements. It can't strike it down. And again, I think this is a recognition of the fact that if the provision had gone that far, then the UK government argument that it was interfering with the ability of the UK Parliament to legislate for Scotland, I think that would, in those circumstances, have been a strong argument. So I think that's why they've hesitated there. Again, this doesn't affect the validity of the underlying provision. And it's maybe worth just noting for interest that similar provisions are contained in the European Charter of Local Self-Government Incorporation Scotland Bill. So that has the interpretation and the incompatibility provisions, but not the strikedown provision. But because it has those, it's been kind of swept up in the reference to the Supreme Court alongside this bill. So our next slide covers a broad range of the sections and just kind of summarizes some of the areas where the government will have a role in any proceedings that come out in relation to the bill. So the Lord Advocate plays a very significant role here. Lord Advocate can institute proceedings if there's a compatibility question that should be determined and is not currently the subject of proceedings. In any proceedings to which the Lord Advocate is a party, he can refer the question compatibility question to a higher court and directly to the Supreme Court if so desired. There are also provisions to ensure that the Lord Advocate and others get involved in litigation. So proceedings that raise a compatibility question, or if a court is considering making a strikedown or an incompatibility declarator, that has to be intimated to the Lord Advocate, Commissioner for Children and Young People in Scotland, and the Scottish Commission for Human Rights. I've noted there that it doesn't have to be intimated to the Advocate General for Scotland, but I think if the legislation in question is an act of Parliament, and in particular if it's a post-devolution act of Parliament, so where the UK Parliament has legislated in a devolved area notwithstanding that the Scottish Parliament could have done so. It may be that the Advocate General for Scotland would want to come in on that, and indeed the parties may want to bring the Advocate General in on that. Going back to the strike-down declarator, the court is able to suspend that declarator in order to allow a remedy of incompatibility. And if considering that, that gets intimated to the Lord Advocate, who can essentially appear and explain what, if anything, the government intends to do to remedy the incompatibility. And the court also has to have regard to the potential effect of a strike-down declarator on non-parties, because the strike-down declarator doesn't just disapply the provision in the dispute in question for the purposes of resolving that dispute. Any provision that's subject to a strike-down declarator will cease to be law going forward to the extent it was incompatible. And then if a declarator is made, the Scottish Government has 6 months to report on any steps it's going to take in response and make a statement to the Scottish Parliament to that effect. Then I think on the next slide, the final point that I'm going to cover, and just very briefly, the concept of remedial regulations. So if the Scottish ministers have identified, or even if they just think that there may be an incompatibility in legislation or indeed an act by the Scottish Government, they can make regulations to deal with that. And again, the regulations can relate to acts of the Scottish Parliament or to UK Parliament legislation that's within legislative competence. And I think just one point before we leave that, there is a lot of, Christine's mentioned some of the legislation incorporating the UNCRC. There's a lot of legislation that authorises the Scottish Government to do things that predates devolution. So the Children's Scotland Act 1995, for example, is an act of the UK Parliament, but is within legislative competence, and the Scottish ministers sort of take over the Secretary of State's role in relation to that, or took it over at the point of devolution. So there are good reasons why acts of the UK Parliament should be caught by these provisions. I think the status of post-devolution UK Parliament Acts and future UK Parliament Acts are probably where the key questions are going to turn in the reference. So back to remedial regulations, these can modify legislation, they can create offences, and they can make retrospective provision, among other things, although not retrospectively create offences. The Scottish ministers can only use this power if there are compelling reasons to do so, and they have to give their reasons for doing so to the Scottish Parliament. There is Scottish Parliament control over this, and regulations have to be approved by the Scottish Parliament before they can take effect. They also have to give public notice of proposals to make remedial regulations with a 60-day comment period. So this will be a more transparent and consultative process than secondary legislation normally would be, although there is an exception for reasons of urgency. So that's a run through the pretty technical provisions of the UNCRC bill and how it relates to legislation. We'll take some questions, but just a reminder, as Christine said, that we do have other sessions coming up in this series. You can see the dates and times there. And if you want to sign up or find more detail, you can just go to the events page of our website that you can see at the bottom there. So in terms of questions, we've got a little bit of time. We've got a couple of questions, but if anybody has anything that they want to add in, I think we will have time to deal with those. Christine, I think question maybe for you, covered this to some extent, but what should authorities be doing now?
I think being alert is probably the first thing, and it is quite challenging. I'm very conscious that quite a lot of authorities continue to be in a situation where they're affected by the pandemic restrictions, and that looking to new legislation and new obligations may not be entirely high on the list of priorities. Equally, I don't want to sound alarmist about that, because it's not me suggesting that 6 months from royal assent there will be a kind of landslide of claims being made against public authorities. I doubt that that's the way that things will work, but certainly from 6 months after royal assent, and I should have said that the Scottish ministers can in fact bring it into force earlier than that if they choose to do so, but I suspect that's unlikely. From 6 months after royal assent, you will be under these proactive as well as reactive obligations. And so I think in terms of what you do now, understanding what the articles of the UNCRC say and the variety of ways in which they make provision for the protection of children and thinking quite carefully about how those rights might interact with your functions, and thinking about how you can embed a children's rights assessment in the decision making that you carry out, because I think that is also going to be really key. That the Commissioner, the Children's Commissioner and others will be looking to public authorities for them to demonstrate that they have properly thought about UNCRC considerations when they're making decisions, and so having processes in place by which that can be done in a concrete way, I think it is going to be the priority.
And just on that subject of timing, so question here, you've covered that it could be up to 6 months from royal assent, but royal assent itself is obviously contingent on the Supreme Court reference. So question of how long that reference might take to be determined. There's only been one, but Christine was involved in it, so has more insight than most. That one may have been a bit more accelerated though, I think.
Yeah, I understand that in fact dates have been fixed for these references in June of this year. So the Supreme Court is intending to hear the references before the summer. And I think the Supreme Court does take seriously these kinds of references in terms of the need for speed. If they, and I would expect a decision from them in the autumn and possibly in the early autumn, if the court concludes that there's nothing to see here, then the bill can proceed for royal assent. If the Supreme Court does find that there are incompatibilities in respect of certain provisions of the bill, then it returns to the Scottish Parliament for the Parliament to consider and for the government to consider what is to be done about the bill in light of the Supreme Court's ruling. So royal assent could, depending on one outcome from the Supreme Court case, be as early as the early autumn, and therefore, by this time next year, certainly these obligations may be in force. If it comes back and requires to be modified, then it might take a little bit longer. But again, you would be expecting the Scottish Government to be moving fairly quickly to try and resolve any technical problems that there are, given the commitment to bringing this into force sooner rather than later. Yeah.
And maybe a question relevant to what I was covering, and the conferring of obligations on UK government ministers and authorities in Scottish Parliament legislation. So question of whether that has been done previously. And interestingly, the letter from the Secretary of State to the Deputy First Minister that identified the concerns about the UNCRC bill and the Local Government Charter bill also referred to a provision in the UK withdrawal from the European Union Continuity Scotland Act 2021, which does confer obligations on UK ministers confers duties on them in relation to acting consistently with the environmental principles set out in that act. That's not been referred, but the UK government, the Secretary of State's letter stated that the UK government's view was that that duty on UK ministers should be read down so that it only applies to them if they're making policy that relates to devolved matters or does not relate to reserved matters. And that would be consistently with Section 101 of the Scotland Act 1998, which says if a provision, not dissimilar to provisions in the UNCRC bill, if a provision can be read consistently with the limits of the Scottish Parliament's legislative competence, then it should be read down to be within competence if that is possible. So it's interesting that the UK government has taken that approach in relation to the Continuity Act, but in relation to the quite a similar obligation or similar provision in the UNCRC bill, it looks like that's going to form part of a reference. Possibly that suggests that their main concern is more about the effect on legislation than about the imposition of duties on UK government. But interesting that they have taken a different view. And it is possible that the Supreme Court will kind of split the baby and say that it's not outside the current bill is not outside legislative competence, but only on the basis that it should be read in particular ways under Section 101 so as to remain within legislative competence, which may end up being sort of a bit of a win-win for both sides getting what they want. None of it gets struck down, but the UK government gets a bit of what they want as well. Okay, well, I think that is probably where we should wrap that up. We'll return 5 minutes of your afternoon to you. There are contact details, so if you do have any questions that you didn't fancy raising in the open forum, then do feel free to get in touch, or indeed if we can assist you with any of the sort of planning and preparation that we've been discussing today. Otherwise, thank you very much for your time, and we'll hope to see you again soon. Thanks.
Thank you. Bye-bye.